Important legal insights for employees earning commissions, especially on termination. To better understand your legal position as an employee earning commissions as part of your employment remuneration, especially where you stand on those commissions when you have been fired, terminated, or otherwise relieved of your job, it is worthwhile to look at the detailed analysis that was undertaken in Matthew Carroll versus Percy Industrial Controls Limited. And even though Carroll versus Percy Industrial Controls Limited is an Alberta court decision, there are many principles that can be taken from this judicial determination, although it would naturally need to be subject to laws, statutes, and case precedent of the relevant jurisdiction, and each situation will need to be subject to its own distinct facts. The judge's written decision provides some very important insights for any employee that derives all or part of their employment remuneration through commissions. And for the purposes of our own presentation, we will merely look to refer to all the depicted parties as either the employee or the employer, with the exact wording of the court's decision being accessible through a link contained in the description to this video. When the Honorable Madam Justice Dawn Pentelachuk set forth her reasons of judgment in the written court decision with respect to commissions earned by an employee, the past judicial history and the pertinent aspects of this case were: the employee, who was terminated on July 7, 2013, claimed for commissions earned up to June 30, 2012, and for commissions earned for the period of July 1, 2012 to June 7, 2013. While the employer acknowledged commissions are owed to the employee, the employer disputed the amount claimed. At the heart of the dispute is whether the employee is entitled to commissions for sales generated prior to his dismissal, but paid after July 7, 2013, his date of termination. There is no dispute that commissions are payable to the employee upon completion of the sales cycle, that is, if and when the employer received payment from the customer. This was an innate understanding by the parties and is consistent with industry standard. However, the point at which the employee became entitled to commission payments was not specifically discussed by the parties. Similarly, the parties did not discuss payment of commissions if the employee's employment ceased. While the employee conceded that the employer paid him commissions after the employer received payment for sales he effected, he argued that his entitlement to eventually receive commissions crystallized at the time the sales were effected. Accordingly, he argued he is entitled to receive commissions for sales that he effected prior to his dismissal, regardless of whether payments were received by the employer before or after the date of termination. The employer argued that the employee's entitlement to receive commissions crystallized at the date of payment. Accordingly, the employer argued the employee is not entitled to receive commissions for sales effected prior to the date of termination if the customer had not paid for the order until after the date of dismissal. One of the owners of the employer testified that the employer's policy was not to pay commissions to employees after the end of their employment. This was confirmed by the employer's longtime bookkeeper. She too testified that employees are paid commissions once the employer received payment, and they must be employed in order to receive their commissions. She said no exception was made for the employee to this structure. For his part, the employee testified that in the electrical supply industry, it is typical to receive commissions owing even if the sales cycles are outstanding at termination. No doubt, if a written employment contract between the parties unambiguously states the employee is not entitled to receive commissions if payment is not received at the date of termination, the employer would be entitled to rely on the contractual provision unless the employee could prove that, in law, the employer is stopped or otherwise prevented from relying on the plainly worded contract, citing the Alberta Court of Appeals decision in Stiles. That, however, was not the case in the present situation, since the written contract, which had expired in any event, is silent on the basis of the employee's entitlement to commissions post-termination. In the case of silence on this issue, two distinct lines of authority have developed. The first line of authority originates from the Supreme Court of Canada decision in Grover, which states, implication of a term in a contract ought to be made only where it is necessary in order to give the transaction such efficacy as both parties must have intended it to have, and to prevent such failure of consideration as cannot have been in the contemplation of either party. This has come to be known as the business efficacy rule, where an unwritten term may be implied if the contract could not otherwise operate without it, as stated in the Supreme Court of Canada decision in MJB Enterprises. In applying the business efficacy test to the facts in the case, the court in Grover concluded that the commissions should not be payable after termination unless there is an express term to that effect. The test outlined in Grover was applied in the Newfoundland court decision in Bixby, where it was held that absent an express term in the commission salesman's contract of employment respecting payment of commissions for sales completed after termination, there must be some factual basis to justify the implication of such a term. In that case, the court heard evidence that established the company's policy was not to pay commissions after termination for uncompleted sales, and that this policy was well known amongst the staff. Accordingly, the salesman was not entitled to commissions for sales effected where payments were received after the date of termination. A similar approach was followed in the Manitoba court decision in Schwartz, a case which predates Grover. In that case, the evidence from the employer's manager that the commissions were payable just while the plaintiff was in their employment was sufficient grounds to defeat the plaintiff's claim for commissions. Citing the England Court of King's Bench decision in Marshall, the court found that unless there are words in the contracts showing with reasonable clearness an intention on the parties to continue the commission on trade done after the date of termination, the plaintiff cannot succeed. In the Saskatchewan court decision in Miller, the court interpreted an employment contract with a car salesman which contained the term specifying that no sale shall be considered made and no commission due to the plaintiff until the purchaser has taken delivery of the vehicle. The court found that this language was sufficiently clear to deny the plaintiff recovery for commissions on vehicles sold but not delivered at the date of termination, and there was no basis to imply a term to the contrary. A second line of authority flows from the leading English case of Sellers versus London's counties newspapers, where it was decided that absent a term to the contrary, an employee is entitled to commission on sales effected by him but not payable until after the termination of his employment. Sellers was followed in the Manitoba court decision in Manson. In the instant case, there was clearly no express term in the contract that the plaintiff's right to commission should end with the termination of the contract. Further, I can see no point of distinction between a situation where orders have been placed during the employment and one where orders are ultimately placed by reason of the efforts of the plaintiff during his period of employment. If it were otherwise, the employer could, in any case, conveniently terminate the employment prior to the placing of orders and thus avoid liability for commission. While Sellers was not explicitly cited, the Ontario court decision in Micallef essentially adopted the same approach. Based on the evidence of McMaster, however, there was in place a basis for calculating commission on sales. To the extent, therefore, that sales were consummated by the plaintiff, I am of the view that he is entitled to the appropriate commission on those sales. I reject the position given by the defense, however, that the plaintiff had to be in the employ of the defendant at the time payment was received in order to be paid the commission. Absent some explicit policy to that effect, and there is no evidence to that effect, the distinction must validly be made between the time a commission is earned and the time that it becomes payable. It is perfectly reasonable for an employer to say that a commission will not become payable until the account is paid. It is quite another thing to say that the commission will not be paid simply because an employee was not in its employ at the time the account was paid, notwithstanding the fact that the sale was a result of the employee's efforts. A similar approach was followed in the New Brunswick court decision in Hawkins, where the court found that the employee's right to payment for commission on a sale crystallized when nothing further remained to be done by the employer to collect on the sale. Since the sale could be attributed to the sole efforts of the terminated employee, that gave rise to an entitlement to the commission from the sale, absent a clear term in the employment contract to the contrary. In the Alberta court decision Avery, the employment contract contained an express term stating the employee would be paid commissions for vehicles sold payable at the end of the month following delivery of the vehicle. Following Micallef, the court found that the timing of the commission's payment in the contract was not determinative of whether the employee's entitlement to the commission had crystallized at some point earlier. Rather, the court found that the employee's entitlement to payment for commissions crystallized at the date the sale was concluded, even if payment for the commission was not made until sometime thereafter. Since the contract was otherwise silent on whether the employee was entitled to commissions earned but not paid at the date of termination, the court found that the plain meaning of the contract entitled the employee to commissions earned, even if the payment was not to be made until sometime after the date of termination. In the British Columbia court decision in Gill, the court cited Manson, Micallef, and Hawkins with approval, but ultimately distinguished these cases on the basis that the employee's commissions in Gill were earned on the basis of the overall profitability of the firm as opposed to sales effected. Once his employment was terminated, it became impossible for him to earn further commissions since he could no longer claim to have contributed to the company's profitability in subsequent months. It appears from review of the case authority, the courts have not hesitated to imply a term in employment contracts requiring the employer to pay terminated employees commissions for sales effected but not concluded prior to the termination. In the Alberta court decision in Rolls, the judge, after providing a thorough review of the authorities, found that implication of a term in the employment contract was clearly applicable, and the employee was entitled to commissions on sales he effected while employed, the invoices for which were sent out after his employment was terminated. In rationalizing these apparent diverse lines of authority, I considered, this being the judge, the following factors to be germane. It is clear from the evidence that the employee completed his role for all of the commissions claimed. He was directly involved in each and every one of the sales in question, and the sales can be primarily attributed to his efforts, similar to the case in Micallef. Further, it is clear on the evidence that the employer had now been paid for all of the sales, although specific dates of payments are not in evidence. While there was evidence from the employer that their policy was not to pay commissions following termination of employment, there is no evidence before me that the policy was ever brought to the attention of the employee. nor was he ever asked whether he was aware of this policy. The employer's bookkeeper's testimony supports that a general policy was in place, but her testimony does not prove that the employee was subjectively aware of that policy. Even if it is not reduced to writing, credible evidence established the existence of a term precluding employees from collecting commissions earned post-termination may well justify denial of commissions on sales paid after termination, as was the case in Bixby. Further, it is open to the parties to lead evidence as to widely known and accepted industry practice standards. No such conclusive evidence is before me, that being the judge. Furthermore, the fact that commissions were typically paid out after payment was received from the purchaser does not necessarily imply that such commissions are not payable following termination. Following Micallef, a term in an employment contract requiring that in order to be paid before the salesperson receives his commission does not necessarily imply that the salesperson's entitlement to that commission crystallized at the date the customer pays the invoice. Rather, it is entirely reasonable to conclude that the employee's entitlement to receive a commission crystallized at the date the sale was effected, even if payment is delayed until some time thereafter. At that point, the employee's job has been performed, and the employer is set to reap the benefit of the employee's labor once the customer remits payment. In Madam Justice Penelechuk's view, this interpretation properly applied the business efficacy test as set out by the Supreme Court in Grover and MJB Enterprises. The court should imply terms that are necessary to give effect to the consideration agreed to between the parties. In the case, the employer agreed to pay the employee a base salary plus commissions in exchange for the employee effecting sales on the employer's behalf. It is reasonable to apply a term that the employee's entitlement to commissions crystallized at the moment the sale was effected, because that best gives effect to the consideration agreed to between the parties. At that point, the employee had performed his duties, and he is entitled to the compensation for his labor that he bargained for. To find otherwise would lead to a windfall for the employer. This, in Her Honor's view, is also consistent with what she termed the modern approach to this issue. It recognized that where an employee's compensation is based in whole or in part on commissions, a dismissed employee will be compensated for the loss of the opportunity to earn commissions over the applicable notice period, citing numerous cases. Her Honor concluded that where an employee has been dismissed and the employment contract is silent on this issue, absent evidence of known company policy or accepted industry standard, a court should not hesitate to imply a term that commissions earned on sales generated before termination but paid to the employer after termination should still be paid to the employee. Accordingly, Madam Justice Pentelechuk determined that the employee was entitled to commissions for sales generated, including on sales paid after his termination. For commissioned employees whose employment has ended, our law firm is committed to ensuring that you are fully paid for the work that you have undertaken for your former employer and legally earned. Thank you.